5 seconds to go. Start. The reason why the appellant suddenly, on seeing the septuagenarian PW2, would go to his house and return with a knife is not there in the evidence. Stop. We shall, for the present, assume that there were heated exchanges and that the appellant gave a blow to PW2 first, and thereafter to the others one by one. Stop. Then again, the victim who, according to PW2, was supposed to be in the field but appeared in the scene from some other place all on a sudden, was the third in the series to be stabbed by the appellant and, thus, was not his target. Stop. Though there is no specific admission by the appellant that he had stabbed the victim or the other injured witnesses, reading of the contents of Exhibit 96 does evince an act of retaliation spurred by sudden provocation, resulting in a quarrel as well as a scuffle, which ultimately, most unfortunately, cost the victim his life and left some others injured. Stop. The appellant too sustained injuries in the scuffle, and there is evidence on record that one of the injuries was grievous, yet, the criminal law was surprisingly not set in motion to bring to book those responsible for inflicting such injury. Stop. It was in a sudden quarrel, which could have been provoked by the victim and PW2, that blows followed from each side. Stop. Most importantly, the circumstances in which the incident occurred does clearly negate any suggestion of premeditation in mind. Stop. That apart, it cannot be overlooked that while the victim was middle-aged, the appellant was in his late 50s. Stop. At the time of the alleged incident, apart from PWs 2 and 3, all three not examined were present at the spot, as per the version of PW2. Stop. It is indeed improbable that in the presence of such persons, the appellant wielding a weapon like a knife would come to the spot with an intention to commit the offense of murder, overpowering all of them without any sufficient reason or provocation. Stop. In our opinion, the trial court lacked in objectivity by not examining the facts and circumstances as to whether the situation was such as is likely to reasonably cause an apprehension in the mind of the appellant that there was imminent danger to his body, of either death or grievous hurt being caused to him, if he did not act in private defense. Stop. To impute intention to cause death or the intention to cause that particular injury, which proved fatal, in these circumstances seems to be unreasonable. Stop. Para. Exception 4 to section 300, IPC ordains that culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offender having taken undue advantage or acted in a cruel or unusual manner. Stop. The explanation thereto clarifies that it is immaterial in such cases which party offers the provocation or commits the first assault, Four requirements must be satisfied to invoke this exception, viz. It was a sudden fight, there was no premeditation, the act was done in a heat of passion, and the assailant had not taken any undue advantage or acted in a cruel or unusual manner. Stop.